All right, Ms. Brink, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in Brink versus Hildebrandt, case number 11140050. The record should reflect Ms. Brink is present today by Zoom video. Ms. Kraus, can you tell me the status of this file today?
This hearing was adjourned from August 5th to allow the plaintiff to obtain friend of the court forms regarding disability and complete and submit them back before today's hearing. No information has been received regarding her inability to work. The only contact the office has had with the plaintiff is on August 12th when she dropped off a letter requesting to sign off her rights to the child and support to stop. Friend of the court staff did indicate she may need to reach out to probate court to move forward regarding that information. And outside of that, the plaintiff has a support obligation of $197 and a balance of $8,709.16. The last payment was received in February in the amount of $206.47 from a prior income withholding.
Okay, Ms. Brink, why did you not submit those forms as you were ordered to at the last hearing?
I never received them.
Okay.
They were supposed to have been mailed to me.
Did you go in to get the forms?
They were supposed to have been mailed to me. That's why I provided my address at the last court hearing.
Okay. Did you do anything to follow up with that at all?
I mean, it's not really my responsibility when someone doesn't do their job.
Well, it's your responsibility to pay your child support payments, and if you don't
But
pay
that
those
has nothing to do with the disability paperwork.
okay, I'm not going to argue with you. We went through this. Yeah, you are, and we went through this at the last hearing. We confirmed your address. We told you
so that they could be mailed to me, which they were not.
They were mailed
and I
to
would
you.
like to sign off my rights to my children. And Devin said that he would not fight it. Bill did not fight it. He came and he signed. And when it came time for Devin to sign, he didn't show up. And I have a text message saying that he doesn't want, or that he wouldn't fight me on signing off my rights to Lila or John. So I'm not sure why he didn't sign the paperwork.
So you still are the parent and you still owe the child support.
But I'm requesting the court to terminate my rights to my children. She has a stepmom that can adopt her. I don't want anything to do with her anymore.
Personal feelings do not change legal responsibility. Whether a parent chooses to stay involved in a child's life or believes another adult can step in has no legal weight on its own. Those decisions mean nothing unless a judge formally reviews the situation and issues a written court order. Until the court officially releases a parent from responsibility, both emotional and financial duties remain fully in place. The law does not operate on personal opinions, promises, or assumptions made outside the courtroom. Parents remain legally required to provide care and support for the children they brought into the world. These obligations exist to protect the well-being of the child, who relies on that support for stability, safety, and daily needs.
Well, there's a process for that, and that process hasn't occurred yet, which means
okay, well, I've asked for that process to be started a year ago. This is the second time I'm bringing it up.
Okay, well, you have to do more than just ask. It's up to you to
well, that's why I had the document written up and by an attorney, and so that Devin would sign the paperwork, and he said he wouldn't fight me, and then he didn't show up to sign it. So I don't understand what the big problem is.
Okay, so how are we going to deal with you paying your child support till that happens then?
I don't know. I have a paycheck coming from Boyne River, and you can have that. Okay. But other than that, I have $34 to my name. My house is for sale, and I'm living in my car.
When are you getting that paycheck?
I don't know. It should be garnished. I probably won't even get a paycheck. It should be garnished by child support.
Do we have an income withholding, Ms. Kraus, for any employers with Ms. Brink?
There is a potential income withholding, but it wasn't reported. So outside of her indicating where she's employed today, that process could take 6 to 8 weeks. So I can't guarantee that monies would be withheld from that paycheck.
Yeah, it should be. I've never had a problem with it not being withheld in the past.
Okay, well, we don't have the information from your employer, right? Ms. Kraus, is that what you're saying?
Yes,
She's
you
never,
do. Oh,
Correct.
they reported it.
hold on, Ms. Brink. Ms. Kraus?
An income withholding was sent, but until monies are withheld, we wouldn't be able to indicate if that amount would be withheld. But the employer was not reported. It's pending, so I can't guarantee that the employer received anything.
They did.
Okay.
They told me.
Well, we haven't received any money from them, so apparently they haven't.
I haven't gotten the check yet. I haven't even been, I get paid every 2 weeks. And I've already lost the job. They already fired me.
So you're
I'm
not employed.
sure.
You're not employed is what you're saying.
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Okay. What about the disability? Where are you at with that?
I filled out all the forms that they requested from me and mailed them back in the timeline that they gave me. But I'm living in my car, so I don't have access to my mailbox anymore. So I have to contact disability today after I get off the phone or after I get out of court and report my address to be at my parents' house. There's no guarantee that they're going to tell me that the disability paperwork comes. I'm going to have to, I don't know what I'm going to do because I don't have gas to get to their house. And they have me blocked on the telephone.
According to the account presented, her employment ended after ongoing conflicts in the workplace, and even her family has chosen to cut off communication. When multiple areas of life begin to fall apart at the same time, it often signals that the issue may not be external, but personal patterns of behavior that need honest reflection. There comes a point where placing blame on everyone else stops being productive. Self-examination becomes necessary when the same problems continue to repeat, regardless of the setting or the people involved. She also stated that she is currently without stable housing. While this channel does not typically focus on cases involving homelessness, the circumstances surrounding her situation become clearer later in the video. As more details emerge, it becomes evident how a series of personal decisions led to her living out of a vehicle, without responsibility falling on outside parties.
Your Honor.
Okay. Yeah, go ahead, Ms. Kraus.
In regards to her being homeless, she may be able to reach out to the local post office. They may have something for her in regards to obtaining a P.O. box, but she would need to check further into that.
Well, I don't have money to pay for a P.O. box.
They may have some options for you regarding if you're homeless right now. I don't know the details in regards to that, but it is some information that friend of the court has received in regarding post offices when people are homeless.
Okay, I'll look into that.
All right, well, here's Ms. Kraus, has there been, how many findings of contempt has there been in this case on Ms. Brink?
This would be a first finding.
Okay. All right, so Ms. Brink,
I'm not in contempt, Your Honor. I have no problem paying it. It's just I can't get a job because I have felonies. No one wants to hire me.
I do
I've already put
consider
out more applications. I'm not in contempt, though. I have no problem paying. It's just that I can't get a job. No one wants to hire me.
you are in contempt, first of all. I find specifically that you are in contempt because you aren't doing any of the things that I ordered you to do the last time, and you can't just
Your
say,
Honor,
well,
like what?
like fill out the forms for your disability.
They weren't mailed to me. How can I fill out forms that weren't mailed to me?
I'm not going to argue
I
about.
called and asked.
Okay,
I called and asked.
Now I'm finding you in contempt for continuing to interrupt me during this court hearing and inhibiting the court's ability to conduct this hearing. You're continuing to talk over me. I'm trying to explain to you.
I asked you a question.
You just told me that you're not getting mail at your parents and there's no guarantee that you're going to get your mail. So how do you know that you didn't get this? We sent it to the address that you gave us.
And I was living there up until Friday.
It's not my problem that you aren't getting your mail. All we can do is send.
I am getting my mail.
Obviously, you're
not
not
making sense, Your Honor.
All we can do is send it to you at the address that you give us.
And you didn't.
It's up to you. So you haven't followed through with what you were required to do.
Yes, I did. I called the child support office and asked about it, and they said it was too soon for me to be calling.
going to mute you now so that I can say what I need to say for the record here, because you're continuing to talk over me and I'm not able to conduct this hearing. So the court adjourned the previous hearing in August to give you an opportunity to submit the forms that were required to be submitted. That's your responsibility to make sure that that's done. We had this colloquy the last time about your address. You gave us an address. That's the address we've been using. If you haven't received the mail, that's between you and the post office and you and whatever is going on with the address that you gave us. All we can do is send out forms. If you didn't get them in the mail, then it was your responsibility to contact the friend of the court, go to the friend of the court, make arrangements to get those forms and fill them out. But that's squarely your responsibility. It's your responsibility to pay child support for your child. That's still your child. Your parental rights haven't been terminated. As far as I can tell, you haven't done anything other than say you want that to happen, to make that happen. So you haven't paid child support. You haven't complied with any efforts of the friend of the court to give you options outside of paying child support. So the court finds that you are in contempt. Because this would be a first finding of contempt, the court finds that you should be sentenced to 45 days in the Otsego County Jail. The court is going to order that you turn yourself in to the Otsego County Jail by 5 p.m. today. That's September 3rd, 2024, to begin serving the 45-day sentence. If you fail to turn yourself in to the Otsego County Jail by 5 p.m. today, then the court will issue a bench warrant for your arrest. Ms. Krause, if you can prepare an order to reflect the will of the court on that today.
Yes.
All right. That's all for this hearing today. The court's going to disconnect from Ms. Brink at this time.
That brings us to the conclusion of the first court session. Records indicate that she did report herself as required and completed the full 45-day period of incarceration without incident. With that portion resolved, the case then moved forward. The following hearing is not included here, as it involved a medical evaluation and contained personal details that would not be appropriate to disclose publicly. Out of respect for privacy, that portion has been intentionally omitted from this coverage. What can be shared is that the evaluating professional provided testimony regarding her condition and confirmed that, despite her diagnosis, she was consistently found capable of understanding the proceedings and participating in her defense. With those findings established, the case proceeds to the third hearing, which we will review next.
Yes, sir.
All right, we're on the record in Brink versus Hildebrand, case number 1114050. The record should reflect Mr. Hildebrand is present today by Zoom video. Ms. Brink has not appeared today. This hearing was set for 9 a.m. It's now 9:26. She is not present. Ms. Krause, can you tell me the status of this case today, please?
The plaintiff has a support obligation of $197, and the total amount due is $9,715.16, which includes this month's obligation. There has been no payment since the last hearing when the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. The last payment that was received was from a prior income withholding in the amount of $206.47 in February of 2024. There has been no communication with the plaintiff.
Ms. Krause, I saw you kind of nodding your head. Was there anything that you wanted to add to this?
Yes, it is brought to my attention that the plaintiff is actually in Otsego County Jail as of yesterday. I didn't check the inmate list this morning. I apologize.
All right. In terms of going forward, although we do have that additional information, the court's going to issue a bench warrant for Ms. Brink. Since we do have her lodged already, Ms. Krause, I think what we'll try to do is set that for a arraignment hearing on Wednesday when I have my criminal docket. Mr. Hildebrand, did you want to be present for that?
Yeah, please, if I could.
Okay. When we get the date and time of that, we can contact you. Ms. Krause, do you have Mr. Hildebrand's contact information?
Yes, we should.
Okay. So Mr. Hildebrand, we'll let you know the date and time, but I'm going to try and get that on the docket for Wednesday at some point, and you can join by Zoom as you're doing today.
All right. Thank you. Yes, sir.
Okay. All right, thank you. You're free to disconnect at this time, Mr. Hildebrand.
Have a good day.
Okay, Mr. Brown, you were set for here. You were asked to appear for this hearing today. I don't know if we're going to need you or not, but if you don't mind just staying connected just in case.
Sure.
Okay, thank you. So what we're on the record for, again, this is Brink versus Hildebrand. This is file number 111400. This was set for a hearing today. It was originally on the court's Monday show cause docket. Ms. Brink, you were ordered to appear before the court to show cause for non-payment of child support. We discovered during the course of that hearing that you had already been, that the reason why you weren't appearing for that on Monday was because you were already lodged in the Otsego County Jail on a different charge. So the court then set this for a hearing today. So in terms of the non-payment of child support, the court isn't going to proceed on the contempt for your failure to appear because I'm satisfied that you couldn't based on your incarceration. So the court's just going to proceed on the non-payment of support issue. And so Ms. Kraus, can you tell me the current status of the account and what friend of the court is asking the court to do in terms of the non-payment of support issue?
Yes, the plaintiff has a support obligation of $197. The total amount due is $9,715.16, which includes this month's obligation. There has been no payment since February of 2024. That amount was $206.47. Since the last hearing, the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. And then we would be requesting to further address contempt as the plaintiff has not exercised any due diligence regarding payment or contact her since her release from jail.
All right, thank you. Mr. Hildebrand, was there anything that you wanted to say in regards to this matter?
Not today, sir.
All right, thank you. Ms. Brink, can you address your non-payment of support between the last hearing and now?
Just the only thing I really want to say is that when I get out of jail, I'm going to sell my house and move in with my my church lady, my church friend, and when I sell it, it should be enough to cover the total amount due. So that's my plan, to pay it.
It's important to remember one key detail as this case continues. She already owns a home outright, with no remaining mortgage or loan attached to it. That fact plays a significant role in understanding her financial situation. Her stated plan is to sell that property and use the proceeds to address her outstanding child support obligations. This decision directly impacts several arguments raised later in the proceedings. As the video moves forward, this detail becomes increasingly relevant, helping explain both the court's position and the consequences of her choices.
All right.
I don't have any way of paying it as of now because I'm jobless.
What's the status of your?
Disability has denied me.
What's the status of your current charges there that you're lodged
I
on?
have not. I've been served the paperwork, but I have not been arraigned on it. I get arraigned on it on the 13th.
Okay. Do you anticipate that you're going to be posting bond, or are you going to remain lodged? Okay. All right. Ms. Kraus, what I'm going to do is ask you to set this for another hearing in February. Obviously, if Ms. Brink is currently incarcerated and isn't released on bond, I don't think we can proceed with the contempt at this point if she's incarcerated by statute. So I'm going to ask that you set this for a hearing in February. If she's released by that point, then we'll proceed with the contempt hearing. If she's not released, then we'll determine what the next timeline will be. Okay.
Okay, and then in regards to the bench warrant then for her, for this particular case?
The bench warrant's going to be recalled just because she's lodged. So we really can't proceed while she's incarcerated.
Thank you.
On collections, again, by statute. So we'll set it for February. If she's out in February, we'll proceed with enforcement. If she's not, then we'll set further scheduling from there.
Okay.
Mr. Hildebrand, do you have any questions about how we're going to go forward?
No, pretty much just wait until she gets her legal stuff squared away, and then we're going to go from there, correct?
Yeah, exactly.
Okay.
Ms. Brink, do you have any questions at all?
No, sir.
Okay, thank you. That's all for this hearing today. All parties on this case can disconnect at this time.
Thank you.
Yeah.
Our next hearing is set.
All right. Is that you, Ms. Brink, at the county jail?
Yes, sir.
All right, thank you. We're going to call your name, your case next, so let me find that on the docket here. All right, we'll call People versus Chelsea Brink. That's 25-43389-SM.
John Blair Brown on behalf of Ms. Brink.
All right, looks like we're here for, I'm sorry, Ms. Brooker, go ahead.
Oh, go ahead. Amanda Brooker appearing on behalf of the people.
Thank you. Looks like we're here for a jury status conference. Do we have a resolution, Mr. Brown?
Your Honor, I don't believe there has been an offer in this matter. I'll defer to Ms. Brooker in case there has.
There's not an offer.
This is a simple assault, Your Honor. I believe I sent something to the court on this matter. It is my understanding that Ms. Brink, if it is acceptable, will be entering a no contest plea for any potential civil liability.
I do see an affidavit of probable cause, but I do not see any other documentation that may have been sent to the court today. Is there something specific that you think you sent, Mr. Brown?
That is
I sent 2 pages that I believe.
Yep, I do see that now. Yep,
That is what I sent.
All right, I just didn't know if there was something else specific that you had. So I have received those 2 items. All right, Ms. Brink, your attorney has said that he believes that you wish to enter a plea to the charge of assault and battery and plead guilty as charged. Is that what you want? Excuse me, plead no contest as charged. Is that what you want to do today?
Yes, sir.
All right. If you do that, you would be giving up your trial rights and you would not have a trial because you'd be telling me that you did something that was against the law. Do you understand that?
Yes, sir.
If you had a trial, you would have certain rights. So I want to tell you what those rights are so that you can make an informed decision. You have the right to have a trial by a judge or by a jury. You have the right to have the assistance of an attorney at that trial. You have the right to see, hear, and question the witnesses against you at trial. You have the right to call witnesses on your behalf and to get an order called a subpoena to require those witnesses to appear and testify on your behalf. You have the right to be a witness yourself or to remain silent. And if you choose to remain silent, that silence cannot be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden of proof be on the prosecutor at all times. Do you understand each of the rights that I've just read to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Do you understand that if you enter a plea today, that you would be giving up, waiving, and not having any of those rights other than you would continue to have Mr. Brown as your attorney?
Okay.
All right. Would you raise your right hand, please, so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down. Has anybody promised you anything to get you to plead today other than what's been stated in court today?
No, sir.
Has anybody threatened you in any way to get you to plead guilty?
No, sir.
Are you doing so of your own
Well,
free
kind
choice?
of. Sean John Conrad, gave me a look.
I'm sorry, who gave you a look?
It's the, Your Honor,
Sean John Conrad, did.
it's the victim in the matter.
Simply reacting with aggression because someone looks at you in a way you dislike is not acceptable under the law. Personal discomfort does not justify physical confrontation, no matter how minor the trigger may seem. The legal system is clear on this point. Actions taken without provocation or lawful reason fall squarely outside acceptable social conduct and carry real consequences. Behavior like this reflects an inability to regulate responses in public settings, which is exactly why courts take such incidents seriously when evaluating responsibility and accountability.
How is that making you do
He peered
today?
He peered over the cop's shoulders when I was, and during the course of the interaction, he reached for a knife. So I was intimidated and fearful of him.
Are you talking about at the time of the incident, or are you talking about today?
The time of the incident.
All right, I'm talking about today. Has anybody threatened you in any way to get you to plead guilty today?
Not today.
All right, is that time of the incident, are you telling me that you're acting today because you feel threatened today because of that previous incident?
In a way.
Well, here's the deal. If you're being threatened in any way, I'm not going to take a plea from you. You have to be doing this of your own free choice and free will. And if you're not, I'm simply not going to take a plea from you. I don't want anybody or you to feel like anybody is threatening you or doing anything that would take away your absolute choice in this matter. Do you understand that?
Sure.
All right. And now, in understanding that this is your choice and your choice alone, do you still feel that you're being threatened in any way to get you to plead guilty today?
I mean, I think the cop arrested the wrong person, but I don't feel like I'm being threatened necessarily. But I have nowhere to go if I'm let out of jail because Sean Don Conrady is still in my residence.
Well, we can deal with that later, but today is a day for whether or not you're going to plead. I can't solve all of your problems today. I just simply need to know that you're making this choice of your own free will and you're not feeling actively threatened today to make that plea. Is that true?
Okay.
That you're not being actively threatened today? All right.
Right.
Then I will go ahead and continue with the plea. If you change your mind at any time, you let me know though, all right?
Okay. Thank
All right.
you.
So I'm going to ask you some questions about what you did. Is it true that on January the 5th of 2025, in Bagley Township of Otsego County, that you did make an assault or an assault and battery upon Sean Conrady?
Your Honor, this is a no contest.
I'm sorry, that's true. That's a no contest plea. I apologize, Mr. Brown. Thank you. And you have sent to me, Ms. Brink, do you agree that I can look at some paperwork to determine whether or not you made a plea, an assault, so that you don't have to admit responsibility to that? Is it okay with you if I look at the police report and the affidavit of probable cause? All right, thank you.
Yes, go ahead.
Thank you for bringing that to my attention, Mr. Brown. I appreciate that. All right, I do find from the affidavit of probable cause that Chelsea Brink assaulted or assaulted and battered Mr. Conrady by punching him in the side of the head and neck with her right hand, and that there was a small red mark on the side of his head, and that this was an incident involving being upset about a DVD player and an Xbox cord at the residence in Otsego County, specifically 1336 Groveland Avenue in Bagley Township on or about January the 5th of 2025. I do believe that that satisfies the proper factual basis for the charge. Any other questions as to factual basis, Mr. Brown or Ms. Brucker?
No, Your Honor. I believe there's a factual basis.
And do you believe that thank you, Mr. Brown. Do you believe that we've also complied with the court rule for taking pleas?
Yes, Your Honor. I'm sorry.
Yes, Judge.
All right, Ms. Brink, do you still want me to take your no contest plea?
Yes, sir.
And do you understand that a no contest plea, for all intents and purposes, is exactly the same as a guilty plea, except that I read the paperwork instead of talking to you about it? You understand that?
Yes, sir. Yes, sir.
All right. I will accept your plea. I do believe there's a proper factual basis, and I'll find that you did so knowingly, intelligently, and voluntarily. Let me catch up on my paperwork here. Mr. Brown, do you wish to proceed to sentencing right away?
I would like to, but I mean, there is a victim. in the
Probably
matter.
can't without a
Yes.
victim.
I would have to defer to Ms. Bruker.
Judge,
Yeah.
we have sent him some information. He doesn't have a working phone. We've not heard back from the information we've sent him. So if the court wishes to go forward, I don't have an objection to that. If the court wants to set it out for a week, I'm fine with that as well, and we can continue to attempt to get a hold of him.
I prefer to give him an opportunity, every opportunity to appear if he wants to do that. So let's set it out for 1 week. We'll come back on January the 30th at 1:30. Mr. Brown, do we need to address bond for your client, or are you satisfied the way it is?
Your Honor, I don't think we need to address it. She is actually sitting there on another child support matter as well. So regardless of bond, she is not going to be able to bond out.
All right. Ms. Brink, you understand that?
Yes, sir.
All right. So we'll be back in a week. You'll be able to tell me your side of the story at that time, and I'll hear from Mr. Conradi if he wants to make a statement, and then I'll also hear from your attorney at that time as well. So we should be good to go. So I'll talk to you then.
Okay, thank you.
That brings this particular hearing to a close. The following session was not available for public viewing, so there is no recorded footage to review. However, the next documented hearing took place after her release from custody. Based on the sequence of events, it appears the court may have credited her with time already served on related child support matters, or possibly placed her on probation before releasing her. While the exact procedural details are not publicly visible, the outcome is clear. She is no longer in custody and has returned to court proceedings. As the case continues, her conduct once again becomes a central focus, setting the stage for further legal complications ahead.
It is Devin Hildebrandt and Chelsea Brink. That's file 11-14050-DS. I do see Mr. Hildebrandt is here. Do we have Chelsea Brink with us?
Yes.
Could you put your video on, please, Ms. Brink?
I don't have that capability, sir.
Where are you at right now?
I'm here via phone. Huh?
Where are you physically located at right now?
The Comfort Inn and Suites. I got a room here last night. My dad gave me $1,000. Ouch.
What type of phone do you have that doesn't have video capability?
Galaxy something. It's an Android device.
All right. And you didn't download the Zoom app? You're just calling in?
No, I'm connected via phone. That's the best I can do, Your Honor.
All right. Ms. Kraus, is this your matter?
Yes, for this case with the Hildebrandt, yes.
All right. My order last time was that Ms. Brink submit documentation about job applications. She was supposed to do 10 job applications each week to the Otsego County Friend of the Court. Has she done that?
She has not. There was a voicemail that was left in regards to a couple concerns that were outside of employment issues that were outside the scope of Friend of the Court. That message was left for the other case manager.
That's the most untrue statement I've ever heard in my life. My voicemails
Ms.
were
Brink?
regarding job applications I submitted.
Ms. Brink, I will get to you in just a minute, but you don't get to just interrupt somebody else that's talking. I can't have a conversation with one person if somebody else is talking over that. You will have a chance to say what you need to say.
Lies about me.
Ma'am, you will have a chance to say what you want to say in a minute, but I need to talk to people in order, and it's not your turn. If you're going to do that in the future, I'm going to require you to be here in court. And if you're going to be here in court, you're going to behave yourself just like you would when you're on the phone. You understand that? All right, Ms. Kraus, go ahead.
Yeah.
As to the voicemail and the contents, it would be more appropriate to speak to the other case manager. Her obligation is $197. The arrears for this specific case is $10,604.42. The only payment that's been received was a payment in April and May. $100 was received, but $49.37 was distributed to this specific case each month.
All right. I do see Mr. Hildebrandt is here as well. Mr. Hildebrandt, have you received any child support payments from Ms. Brink?
No, sir.
When was the last time you did?
I want to say it was in May, and it was like $45 or something.
All right.
I think I might have received 2 payments possibly. And
Same
that
ones that Ms. Kraus was just talking about?
Yes, sir.
All right, Ms. Brink, please tell me why you have not done the 10 applications per week and submitted them to the friend of the court.
I've been in the hospital for the last month. You ordered it.
I ordered you to be in the hospital for last month?
Yes. The police came to my house and said they had an order from you saying to go to the hospital. So I went to the hospital with them.
Which hospital did you go to?
Well, they took me to Otsego Memorial Hospital emergency room and then transported me to D6 at Munson in Traverse City after that.
When were you
So I've been in
released
the
from the
hospital
hospital?
for the entire month, but I did submit applications to a few places. I left a voicemail on friend of the court and the prosecuting attorney's voicemails saying that I did that. And I had a job interview at Taco Bell yesterday, but it's really just not. I'm in a ton of pain. I've been in 2 car accidents, and I'm homeless. So getting a job and making child support payments is not at the top of my priority list, although I know it is at the top of yours because my children need support, but I just can't right now. And I apologize for that, but there's just really nothing I can do. I don't know what to do. Nowhere seems to be hiring. I'm doing the best I can, to be honest with you.
It's true that having a felony record can create additional challenges when seeking employment, but it does not automatically eliminate every opportunity. Many people are still able to work, rebuild stability, and move forward when they take responsibility and make constructive choices. The real barrier arises when past legal issues are combined with ongoing behavior that raises concerns for employers. Consistent conduct, attitude, and accountability play a major role in whether someone is willing to offer a second chance. When negative patterns continue unchecked, they compound existing obstacles and make progress far more difficult. Courts and employers alike tend to focus not just on history, but on whether meaningful change is taking place.
What were you in the hospital for?
I don't even know. You ordered me to go to get checked out. That's all I know. And they sent me to the mental health. I guess supposedly it's a mental health unit.
When were you
not the
released
first time it's been ordered.
When were you released from the hospital?
2 days ago. I'm going to Petoskey's Mary Margaret house today to sleep on their couch. That's the best they can do. I have nowhere to go. And if I do that, I'm going to miss out on the Taco Bell job, but I don't know what to do. It's either that or sleep in my truck, and I can't keep sleeping in my truck.
Do you have a community mental health caseworker, Ms. Brink?
Supposedly, I don't know. They're not really doing their job, to be honest with you, but I have an appointment with community mental health in I'm sorry, I'm having a hard time speaking because I'm hurting, but in between 3 and 4 days from now, I have it on my discharge paperwork. If I looked at it, I can tell you the specific date. I think it's I don't know. I think it's a Wednesday or a Thursday this coming week. But if I go to the Mary Margaret house, I'm going to miss that appointment. So I don't know what you want me to do. I can do either or, but I'm going to struggle if I sleep in my truck for the next week. Luckily, I have
What I want you to do is contact community mental health. And if you need to change the appointment, you change the appointment, but you go to your appointment so they can help you find not only mental health treatment, but you can find housing. There's places in Otsego County that deal with people who have difficulty finding housing.
I've tried. United Way is closed, and that's the only place that helps with housing. NEMSCA doesn't help with housing, and that's it. There is nowhere in Otsego County that helps with housing. I've called all the numbers. I even went to the Goodwill Inn in Traverse City, and they rejected me.
Because of your behaviors?
No. Has nothing to do with that. My behavior is fine, sir.
MDHHS,
sorry that you don't like it, but that's not the truth.
Ms. Brink, you need to stop when I start talking. MDHHS helps with housing all of the time. Have you made an application there?
Sir, I've made all the phone calls. They're not helping with housing. If you'd like me to prove it to you, I can give you the numbers and you can make the phone calls yourself. But they're not helping me with housing. Well, don't say something that's not true.
Ms. Brink, you still have a responsibility to apply for work, whether it's difficult or not.
And I am.
You have not, because you've not submitted those to the.
Yes, I have. I've been in the hospital. What do you want me to do? You ordered me to go to the hospital. You can't have your cake and eat it too, sir. I'm sorry.
Chelsea,
and I don't care if you think I'm being rude right now, but that's the truth.
Yeah, please watch.
We're good. We're good, Mr. Brown. Thank you, though. I appreciate that.
No, you need to let my attorney speak if he's going to defend me. That's his job. You ordered for him to represent me.
Ms. Brink, what he was going to do was tell you to be quiet, not me to be quiet.
No one needs to be quiet. There's no reason for that.
Ms. Brink, when
We're
did you
having
go
a conversation to figure this out. Maybe if you hadn't taken my kids from me in the first place, we wouldn't be in this situation.
At some point, accountability has to replace excuses. When responsibility for repeated problems is placed on everyone else, meaningful progress becomes impossible. Real change begins with an honest examination of one's own choices and conduct. The judge's observation in this moment is especially telling. Counsel was not acting in opposition to the court, but rather attempting to guide the client away from decisions that were causing further harm. In situations like this, legal representation serves not only as an advocate, but as a safeguard. Sometimes the most effective defense is protecting a person from the consequences of their own actions.
That you wanted me to be checked out, and so they sent me to Munson. And I just got out 24 hours ago, so I'm sorry that I haven't put job applications in, but I'm in a ton of pain. And I will.
All right, good. We're going to adjourn this for a month. You're going to do the 2 applications a day, 10 applications a week to the friend of the court. We'll have another hearing.
I'll do as many as I can, but I'm not going to waste my gas when I'm not getting hired.
Ms. Brink, that's a court order. If you're not going to do a court's order, you're going to be in contempt of court.
Whatever.
All right. Ms. Kraus, would you please make sure that that's in the next court order? That's all for today then. Thank you very much. Ms. Brink, you have one more case, so you need to stay on the line until that case is called.
Your Honor, could you repeat the amount of job application?
Yeah, please mute Ms. Brink. All right, Ms. Kraus, the order is that we adjourn today's hearing 30 days and that she submit 2 applications per day or the equivalent of 10 applications per week, just like the previous order.
Thank you.
And then we'll simply have it reviewed in 30 days. All right. Thank you, Mr. Hildebrandt. That's all for you today. You're free to go.
Can we, I got a question, Your Honor.
Go ahead.
The last hearing that we had that I was not allowed in on, I know Miss Kraus brought up the fact that she had sold her home and that it just got overlooked in the last hearing. It was mentioned and then nothing else was said about it. She had plenty of income to pay a little bit of her child support or some of her child support when she sold her house for $30,000.
All right, Ms. Kraus, do you have any other information about that?
Outside of, it wasn't at the last hearing. Unfortunately, I wasn't present for that. I believe the other case manager handled the Mays one, but in April, we did receive information. Let me just look at my last notes.
I don't recall that off the top of my head. That's why I'm asking.
I do remember there was conversation that we did have notification or we were able to see that that property was sold online, but we weren't able to find the amount. It was addressed, but I don't know exactly what had happened in regards to that.
All right, between yourself and the other case manager, would you assist me in trying to pull up some statistics or facts on that? Get me as much information as you can, and we'll review that again at the next court date.
Absolutely.
Thank you, Mr. Hildebrandt. We'll deal with that then. All right, sir?
Yes, sir.
And if you, Mr. Hildebrandt, if you have any other additional information, would you submit that to the friend of the court so that they can get that to me so we can address it on the record?
Yeah, I feel that it's always been just a blatant refusal for her to even pay any amount of child support, especially if she was just gifted $1,000 from her father yesterday. Should we expect a little bit of a payment? I understand that she's homeless and all, but that's by her own free will. She's the one that sold the house that was paid for. It's not a pity party for Chelsea today. It's, you have an obligation, you have children, support your children.
Yep, I understand that. But today's not the day for me to do that because I don't have all that information in front of me, and I'd like to have it before I make a decision. So we'll deal with it in 30 days. Thank you, sir.
Yes, sir. Thank you.
All right. All right, the next case is William Mason and Chelsea Brink, file 13-15199-DC. Ms. Brink, are you still with us?
Yes, I am, sir.
All right, thank you very much. I'm going to ask the friend of the court to update me on this particular case, and then I'll give you an opportunity to present your side if you wish. Go ahead, Ms. Spillane.
This matter was adjourned from May 30th, and similar to the last case, she was supposed to provide 10 job applications each week. Support obligation is $202 a month plus $50 ordered on arrears. Her current balance is sitting at $13,107.99, with the last payment received in May of $50.63.
All right.
I paid 2 payments of $100 each.
In April
And like
May,
I said,
right?
I've been in the hospital.
Yep, I remember that. Do you have any
And I'm
dollars?
homeless.
Do you have any dollars currently available to you to make child support payments?
No, I do not.
Did you receive, you mentioned receiving $1,000 from your dad?
I'm homeless, sir.
I'm sorry, I didn't hear that.
I'm homeless. I'm not
All right,
paying
but
child support when I'm homeless.
You have an
My
obligation.
kid's not homeless. He has clothing, food, toys, big screen TV, Xbox. He's got everything he needs. His dad does not ask me for money. I've called him, spoken with him twice, agreed to let me see him and talk to him. That still hasn't happened. Called him when I got out of the hospital. He was one of my first calls. Didn't answer. Nothing needs to be paid. Technically, I don't even owe that because all of that happened when I was incarcerated for a year in the Otsego County Jail. So it needs to be remedied, to be honest with you.
Ms. Brink, did you sell your house in the last few months?
Yeah, and I was homeless, so most of my money went to hotel stays because my parents have dementia and can't understand that I'm homeless and need to move home.
How much did you receive from the sale of your home?
I don't remember.
Did you receive documents that told you how much you received?
No, I did
from the
not.
sale?
No, I did not receive documents.
I find that hard to believe, ma'am, that you can sell a house.
Well, you can if you want, but I did not receive documents.
Who did you sell the house to?
I don't know. It was a company.
Which real estate agency?
And the other reason I sold my house is because Brian Morgan, who you just spoke with a little bit ago, proposed to me when I was living at the sober living house getting treatment for alcoholism. And He proposed to me, said to move down there, that he could get me a job at Lucky's Steakhouse. Did not follow through on that. I got a job at Italia Gardens, and then they fired me. And I did make payments when I was working at Italia Gardens.
The most harmful choices someone can make while in a rehabilitation or sober living program is forming a serious romantic commitment with another resident. These environments are designed for personal recovery, stability, and self-reflection, not emotional dependency. When two individuals who are both working through major life challenges become romantically involved, the focus often shifts away from healing. Instead of prioritizing treatment and accountability, attention can turn toward the relationship itself. This kind of situation frequently creates added pressure, distraction, and instability. Rather than supporting recovery, it can increase the risk of setbacks, making long-term progress far more difficult for everyone involved.
Which real estate agency did you use to sell the house?
I don't remember. I think it was Smith Realty or something.
What did you do with the money?
So
once
the
you
only
received
reason I
it?
sold my house is because I was cleared down in Davison with no money, no job, no vehicle, no support from my family, and I couldn't get back up north to take care of my house.
What was the address of your
I
house?
didn't want to sell it. I had no choice.
Ms. Brink, what was the address of the house that you sold?
Groveland Avenue.
And when was the sale?
I don't remember. May something or March. I'm sorry, March something.
March of this year?
Mm-hmm.
Do you recall who you sold it to?
No, I already answered that question once, Your Honor.
Your Honor,
Yes.
I just pulled it up on the county's equalization site. It shows that it sold March 25th for $37,000.
Thank you very much. I appreciate that. All right, Ms. Brink, I'm going to ask the friend of the court to prepare paperwork to send to you so that you can show cause as to why you've not made child support payments out of the funds that you received from the
I did. I made two payments of $100 each. It doesn't matter that I didn't pay the entire arrears. I made payments, period.
I'm going to ask the friend of the court to send me documentation of the information that they have about the house and about the money that you received from the house, so I can determine whether or not you made sufficient payments.
No, that's illegal. That's illegal. It doesn't matter that I didn't make the payments in full for the arrears. The state law says as long as you made an effort, and I did.
That's a good faith effort out of available resources is what the phrase is.
Yeah, and I did. That was all I could do. By the time I got back up here to make payments, the money was damn near gone.
You'll have an opportunity to show me that at a future hearing, but I want you to have the
I don't have
information
receipts
about
for
that.
anything, so how am I going to show you that, Your Honor?
You're going to have to tell me about it then.
I just did tell you. Now you're just being facetious, rude.
All right. You'll receive documentation from the friend of court.
You are an adult. You can hear me.
Ms. Brink, you're going to receive documentation from the friend of the court.
I have no
setting it
mailing
for
address,
hearing.
so I don't know how I'm going to receive documentation. You'll have to send it to my parents' house, and I'll be lucky to get it. Like I said, they have dementia. I'm trying to take care of them. Very difficult to take care of two children, two baby dads, because that's what they are. They're not grown men. They're little boys. Men do not ask women for money, to be honest with you. Not in the world I grew up in, and probably not in the world you grew up in either, Your Honor. And I have two parents that I'm trying to take care of that have dementia and diabetes, both of them.
All right. Ms. Brink, that has nothing to do with child support matters.
But
What we're gonna
that's
do is-
all. That's all circumstances that are related to it that need to be taken into consideration.
At the next hearing, you may be right, but not at today's hearing.